So I have contributed religiously to my 401k plan. However, I think I'm about to go through a divorce from my spouse. Are they entitled to my 401k plan? It's all my money, not his or hers. Hi, I'm Sergio Cabanas, attorney at law here in Florida. And today we're going to talk a little bit about 401k contributions and how they're handled in a divorce case. Like most assets, 401k contributions are also considered to be subject to Florida divorce law. That means that contributions made before you got married may end up going to you. However, contributions made during the marriage may end up being divided with your spouse on an equitable basis. Now, what happens if you're already receiving distributions from your 401k plan? Well, if you've already retired and you and your spouse have been receiving these distributions or withdrawals on a regular basis, it could be considered income and can still come into play in your divorce case. So this is relevant when it comes to determining things like alimony and or child support payments. So as you can see, this issue can also get a little complicated in a divorce case, which is why it's so important to have a good, experienced attorney on your side guiding you through this process. It's definitely a must, especially in high net worth cases. So don't take any chances. I hope this short video provided you with some general guidance on this very important topic. Thank you again for watching, and as always, stay informed so you could stay strong.